It is July 13th of 2026, and this is the Court Gallery. We start with Judge Hesselink, who has to explain to a man why he can't just keep a truck he barely paid for, and why his transportation issues are not the court's problem. Then we jump over to Judge Buckley's courtroom, where one man's complaints about his neighbors escalate to him describing toddlers wandering into traffic and climbing naked onto the roof. And finally, in Judge Gauthier's court, we'll hear a self-defense instructor verbally dismantle his attacker with a brutally direct victim impact statement, and witness the sentencing for a crime so disturbing, the judge admits he had to research punishments because it falls so far outside of normal human behavior. Buckle up, ladies and gentlemen. All that and more starts right now.
Is Michaela Moore and Austin May, 26-42091-GZ. We have both of those parties present with us.
Yes, sir.
Ms. Moore, can you unmute yourself? All right, looks like you were successful there, Ms. Moore. Can you hear me?
Yes.
All right. Can you put the phone down so I can see you clearly, please? Thank you. All right, we were here last in May. I asked the parties to meet, try to figure out a way to resolve this. Excuse me, we're here last in June. I asked the parties to meet and try to resolve the case. Were you able to do that?
Your Honor, we did meet up. We still haven't came to an agreement. The mechanic ended up taking the truck. I told Michaela the same thing. I had to pay $1,000 with agreement to get back and forth to work. As long as court goes good, then I will continue to pay what I owe them. If it doesn't, then they take back the truck. But Michaela doesn't want to listen to anything I have to say. She just wants to sell it. She doesn't want my money, but I can't do that because it's my only transportation to and from work. And, you know, nobody will get money if that happens.
So what is your proposal to how to resolve this matter?
I've told Michaela numerous times that I'm willing to give her money, and she doesn't want to listen to me. She just wants the truck back.
What kind of money are you talking about giving her?
I told her I can give her a loan sum. I was talking about $1,000 this Friday I can give her.
What's $1,000 going to do for her in comparison to the truck?
Well, I also had to pay the mechanic's lien as well.
I understand that, but what does she owe on the truck?
I'm not too sure. Last time she told me it was less than $2,000.
Ms. Moore, what's owed on the truck?
I do believe around 1,200.
So $1,200 and you're free and clear?
Yes.
So if he comes up with $1,200, you don't care if he keeps the truck, right?
I mean, I kind of do because I put all the money towards, like, I made all the payments, and the only thing he did is take it to the mechanic, and I had told him he was the one driving it, so I shouldn't be the one held responsible for the damages, because if it was vice versa, I was driving it and I had the damages, I wouldn't expect him to pay.
All right, let's not pick a fight where we don't need to. So how much did you pay for the truck?
$5,000. That's my loan.
And $1,200 to pay it off, so you paid everything but $1,200, right?
He's made 2 payments of $200.
So $400. So $1,600 would be for that, right?
Yes.
So, Mr. May, what are you going to do about the other amount of money that you owe that she's paid for on the truck?
I'm willing to make payments and get that all squared away.
Okay, why should she have to wait for payments?
She didn't have to. I was at Excel and I ended up losing my job and I didn't have any money, but now I got a good job and I'm willing to make money or make the payments, and I don't see an issue.
Why can't you go to the bank and get a loan on it and then pay her off?
I can't at the moment because of my credit. I've already tried that.
So you want her to wait to get paid?
Not necessarily. I told her I'd give her $500 last time we met up, but she didn't want.
You're not understanding me. $5,000 minus your 400 payment, $4,600 is what you would owe her in order to have that truck. You understand that, right?
Right.
So why does she have to wait for you to make a payment?
I mean, I'm not too sure. I mean, I don't really have that $4,000 right now.
I agree with you. I believe you when you tell me you don't have it, but that's how you do business. If you pay for something, you own it.
Right.
And she's the one who's, other than $400, she's the one who has made the payments. You got the use out of it. How long you been using it now?
About a year.
So for $400, who in the world rents or leases a truck for $400 a year? Nobody. Nobody. You couldn't find anybody in the world that would rent you a truck for $400 for a year. So why doesn't she get the truck back immediately? Mr. May, I'm waiting. Why shouldn't she have the truck back immediately?
Because it's my only transportation right now at the moment. And
whose fault is that?
I just had to pay $1,000 to the mechanic in order for me to get the truck back to get to work.
So you used it and broke it.
I mean, it's just the wear and tear on it.
Yeah, I get it. That's what happens when you use stuff. They break. But should she have to pay for that?
I never said she did. No.
So why is she waiting to get the truck back?
I'm not too sure.
So what can you say to her? What kind of enticement could you give to her to make her want to let you keep the truck and accept payments? Have you tried that?
Yes.
What have you offered to her? I've
offered her money. Like I told her this Friday, I can give her a lonesome amount of money. I just got a good paying job. I'm just now getting back on my feet.
How much money?
1,000 this Friday.
1,000 for what? I'm talking total amount of money. How much are you going to pay her to get this truck?
I'll pay her the $5,000 altogether.
That's just making her even. She hasn't used it for a year. You want to wait how much longer? And you just want to make her even. Why would she want to give you the truck now just to get even?
I'm not too sure.
Well, then what do you want to do? Mr. May, how old are you? Mr. May, how old are you?
28.
Why is this like pulling teeth? Why don't you just say, I'll give her more than $5,000 for the truck?
I mean, that's
and make it worth her while. Why can't you say that?
That's not a problem. I mean, I told her whatever.
Well, then why haven't you done it?
Because she made it clear that she doesn't want my money. All this meeting up, she doesn't want my money. She just wants the truck back. I have all the text messages. I have everything else. She doesn't want my money. That's the thing. I'm not
why
trying.
can't you go to your employer or your relatives and say, I got a great paying job. I'll pay you $7,000 if you take out a loan for me and pay this $5,000 loan off so I can have this truck.
I mean, I just got started at this landscaping company, so I don't think that's going to work out for me.
You don't have any relatives that you can go to the bank and get $7,000 for, or $6,000, or whatever else deal you want to make.
I can talk to my dad, but I haven't discussed that to him yet.
What did you think was going to happen today, Mr. May?
I'm not too sure.
Where's the truck at right now?
I currently have it.
It's in your driveway?
Yeah, because I just paid the mechanic $1,000 to get back and forth to work.
That means absolutely nothing to me. It's not a legal reason to do anything. You used it for a year. You should be paying for the when it breaks.
Okay, but the mechanic lien, that's legal.
Yeah, it is. Is there, that was going to be my next question. Is there anything owed on that?
Yeah.
How
$8,000.
much?
$8,000.
That's on you, dude. So the truck's in your driveway though, right?
Currently, yes.
Anything else that you want to tell me today, Mr. May?
No, sir.
There's going to be a possession judgment for Ms. Moore. Truck will be returned immediately. I find that the $400 that you paid her was for the ability to use the truck over the course of a year. So she doesn't owe you a thing, and she'll be able to use the truck to sell it if she needs to pay off the remainder of the note. You will be responsible for the debt because you used the truck to cause the breakage of the truck, the debt to the repair place. Is the title in the truck, sir?
The bank has the title.
All right. When can you get the truck to her place of residence?
Friday.
No, today or tomorrow.
I have to work tomorrow.
So it's not your truck. So when can you get it to her?
Tomorrow.
All right. That's all for today. I'll send you a copy of the judgment.
Thanks.
Thank you.
All right, Mr. Hall and Mr. Tompkins, come on up, please. And I need the two parties to stand and raise your right hands for me. Swear that testimony in this case will be the truth, the whole truth, and nothing but the truth. You may be seated. And counsel you are?
Peter Boom, for Mr. Hall.
Bloom.
Boom,
Boom.
Boome,
And bar number?
55405.
Right, and do you have a notice of appearance?
I did not, I just, I'm bringing this in pro se this morning. So no, I do not have a notice of appearance, but I can get one to you if you need them.
That would be great to get one into
Okay.
our records, please.
I will get one shortly.
Okay. So in reading the petition in this matter, I really had a hard time trying to figure out what the issue is. It looks like there's maybe a property line dispute, a fence issue. I was not quite sure. So let's, I'll let you ask some questions of your client to make clear to me what the need for a protection order is.
All right. So can you explain to the court why we're here today?
Because I'd like to be capable of being in my home and not be approached by other folks, questioning my integrity or what I'm doing.
And when you say approach, who specifically are you talking about?
The Thomas.
And approached, are they approaching you? Where are they approaching you at?
They came to Mr. Thompkins came to my home.
And he came directly to your house?
Correct, knocked on my door.
No.
Woke me from my sleep.
Okay. And what is their complaint?
Kind of a myriad of complaints of a lot of things. Kind of the overview is that my property looks like crap.
So they don't like the aesthetics of your property?
Yes, sir.
And was the aesthetics, were they complaining about debris? Were they complaining about something illegal?
No, just generally everything I do. If I'm just there, there's a question of why.
So they don't like you being on your property,
It seems that way.
is what they've indicated to you.
It seems that way.
Okay. Do you have a junkyard on your property?
No.
Do you have trash spewing about your property?
No.
Have you built anything, permanent structures without code, without county approval, or? So can you give the court kind of an indication of what your property looks like and the size of it?
I own a 5-acre parcel on the corner of 73rd and Zangle Road out in Boston Harbor. It's a beautifully landscaped property that's been there since 1946. That's my intent. I just want to maintain it and keep it exactly like it's always been.
Is it a farm?
It has the capabilities. It's just had chickens in the past, but these days I just have some dogs.
Is it all grassy, or what's it look
It
like?
has multiple services. It's almost like a park-like setting. There's a large field, and there's some areas around the home that have mature landscaping, and then the large growth of trees to the west.
And how long have you maintained that property?
I've maintained that property about 10 years. Prior to that, we've been across the street I've been there 35. My wife's been there 50.
Okay, so stop right there for a second. What do you mean? Did you own a property across the street and then you moved into this property?
My wife was born across the street. My wife and I have been married for 30 years. We've been together for 35. For the duration of that time, we've lived at 1117, which is across the street with her mother multiple times, the family home. Part of the reason we purchased the home across the street was to make sure we could take care of grandma across the street.
Okay. So you own one property, your wife's family owns the property across the street.
Correct.
And this is off Zangle?
Zangle and 73rd. Yeah.
Is that by Boston Harbor School?
Right, kitty corner. Yes, sir.
Okay. So I know exactly which property you're talking about since I ride my bike out there a lot. Okay.
And how long has the neighbors been there?
I'm unsure when the house was built there. I imagine it's been 3 or 4 years. I'm not positive on the exact date it was built. I think it was 2022 or 3. I'm not positive.
Okay, so they built a home,
Built a tiny house on the west end of my property, their property is on the west end of my property, so they built a tiny house there on close to the property line there.
and do you have a guess at how large their lot is?
It's a 5-acre parcel as well.
Okay, so did they build their home in the middle of their parcel, or where did they build their home?
It's very close to the fence line, on my west fence line.
So they built their home on your fence line?
It's 20 feet off the fence line, I imagine the home is.
Okay. Did you have any problems with neighbors prior to their moving in?
No.
And what's your occupation?
I'm a fireman,
How long have you been a fireman?
15 years.
And do you have a criminal record?
No.
And have you had problems with the law before and been in court with?
Juvenile stuff as a kid, I've never.
Is there anything else you'd like to add for the court to know?
I just want to be able to be comfortable in my home.
Okay, so let me ask you some questions.
Sure.
All right, so you indicated that I believe Mr. Tompkins came to your house
Yes.
and uninvited.
Yes.
Has that been a repeated thing, or did he just come one time?
What I'm experiencing is when I go down to the portion of my property that borders their property, I experience pushback. It's always, oh, what are you doing down here? Are you moving? Are you cutting down some trees? Are you doing this? Are you doing every time I go down there? And I kept a long list of that stuff just because it was kind of overwhelming. This is the first time that he's come on my property. And to come on the property, it's not as if he stepped over the fence line. My home is in the center of my property. You got to walk 200 feet up the road, 40 feet
No,
down my driveway.
I know where your home is.
Came a long way to
Okay,
confront
but
him.
has that been repeated?
No, this is a one-time thing that's come to my home.
Okay. And did you tell him at the time that you would prefer he not come onto your property?
In the middle of the conversation, I asked him to turn around and go.
Have you had instances with either of the neighbors prior to that?
Any adjacent neighbors?
These two specifically, the Hopkins, Thompsons, sorry.
At the fence line, we've had plenty of conversation about what, they're concerned about what I'm doing, how it looks. Very critical of everything. We've had last month, we've had their dog enter through the neighbor's property and attempt to get at our dogs. And they don't seem to want to control that either. It seems to just be a cumulative thing.
Okay, so in what I'm hearing from you, Mr. Hall, is that your primary request is you don't want Mr. Tompkins. Is it just Mr. Tompkins, or is it also?
It's both of them.
Okay, so you don't want the Tompkins to have conversation with you.
What I'm feeling is happening is that because their property is in a wetland buffer, they don't have a lot of land, and they've stated that to me before. What they've said is, and I've quoted it, they've said it multiple times, you have all that land, why would you even come down here? And that thought process just hurts me to my core. I gave my soul to be able to purchase this property and maintain it in this manner, and for someone to tell me that I shouldn't be coming down there and I shouldn't be doing this and I shouldn't be doing that. Boy,
okay. So you would prefer that they not speak with you?
I just like not to see them ever, but to please leave me alone.
Okay, well, not seeing them is probably something beyond the authority of the court.
Please don't speak to me ever again. Yes.
Okay. All right. Mr. Tompkins,
Yes.
anything you'd like to say?
As stated, the first time I've ever been on Aaron's property, I rang his bell. I didn't come to his house in the dark or clandestinely. I rang his bell and I asked him a question. What's the plan along the fence line? He and I had not spoken prior to that for over a year, probably a year and a half. No conversations. And maybe a couple of months earlier to the June 29th conversation, he put a large reused metal garage up close to our the fence, shared fence line. And then he started putting up what he calls privacy fences along there. I hadn't said a word, hadn't looked his way. And then when I noticed orange cones next to the fence posts, I thought, what's going, where's this going? So that's when I walked up to just ask him a question. I asked a question. We don't have a property line dispute. I don't care what he does with his property. I've never criticized it. He keeps it pristine. The ugly structures he's put up are only in view of our home. You can't see them from the road. He can't see them from his house. If he distrusts us and dislikes us, I don't know why he would store a vehicle next to our shared property line outside his line of sight. But irregardless, he has that right. I have no issue with that. And I'm happy to voluntarily not speak with him. Our home is where it is. It's at least 50 feet from the fence line. As stated, we have a critical area buffer that runs down the middle of the property. And that's really the only place the home could set. He knew where that house was going when he purchased the neighboring property, or he should have. We've never harassed him. We've never told him what he can and can't do with his property. We've done nothing illegal. We've tried to be neighborly, just converse. He's misunderstood, as stated in his statement. He's misunderstood conversations we've had. He stated he has PTSD and severe mental stress. We were not aware of that. No one's advised us of that. If he had said at the very beginning, I don't want to talk to you as neighbors, we certainly would have abided by that. We've meant no harm. We have no ill intent toward Aaron.
All right. And Mr. Hall, anything else you'd like to add?
Mr. Tompkins stated the last time we spoke was a year and a half ago. At that juncture, it was in regards to what I was doing on the property. At that time, I told him, in no other words, I said, F you, leave me alone. I don't want you. I'm going to be doing what I'm going to be doing here for the rest of my life. Please leave me alone. He knows that. To act as if there's never been anything prior to this is it seems to be an indicator of his state of mind, that it seems he genuinely believes I'm wrong and he's right. And that's the strangest disposition I've ever seen. I wouldn't block my line of sight from those folks if they weren't constant agitation. I wouldn't, I have zero problems with any of the neighbors, and these folks have had problems with every neighbor around them, all of them. And the fact they don't believe it is shocking. I just prefer not speak to them. That's fine with me. But.
Thank you. All right, what I'm inclined to do here is I understand Mr. Hall's request for the order, and I've heard Mr. Tompkins' response that he recognizes now that the conversations have been irritating to Mr. Hall, and Mr. Hall has the right to not have conversations he doesn't want to have. I'm inclined not to enter an order and give this a try where the parties can see if you can coexist. I would do so with the understanding that Mr. Hall has made very clear that he does not want the Tompkins to contact him. And I've not heard anything about violating a property line or doing anything inappropriate on property. So there's no order for me to enter in that regard in any way. So rather than getting law enforcement potentially involved at this point, I'm inclined to say I won't grant the order, but we're going to make a record that Mr. Hall, in the course of this proceeding, has made very clear that he does not want the Tompkins speaking with him and coming onto his property. If that were to happen, then I would view this much differently after we've had this whole formal conversation about this, because now it's very clear to me that the Tompkins understand what Mr. Hall's need is. So I'm going to deny the order at this point with that understanding that Mr. Hall can always come back and say, okay, that didn't work. They continue to criticize this or that. He doesn't want you to contact him. So it doesn't restrict people's abilities to make complaints to the appropriate agencies about, violations of land use law or regulations. That's, you do that within the context of what the law allows. But as far as direct contact with Mr. Hall, he's very clear. He does not want to hear from the Tompkins family.
Yeah, just to clarify, if I may, Your Honor, we have not complained to him about how his property looks.
Okay, yeah, and we don't need to get into that. We're going to give this a shot. And the reason we're doing that is because I much prefer solutions that, parties can buy into on their own without it being forced by a court. I think those are long lasting and I think they're better, but I am willing to enter the order if it becomes necessary. Mr. Hall?
I'm concerned that I'm gonna receive a wave of all sorts of unfounded complaints from this moment out, be it violations of whatever. I feel like that's going to be a thing.
So we'll find out about that. I'm going to deny the order because my sense is that I think this is something that the two of you, I think you now have a pretty good understanding of a little bit of each other in a context in which, it's not just where the two of you are having conversation and it gets heated. It's a three-way conversation, I guess, here. So I'm going to give this a shot. I will say, coming in and asking me to tell somebody to stop calling, animal control or stop calling, the county over land use issues, the court never enters an order about that. It's up to the agencies to decide whether they're valid complaints or not valid complaints. Mr. Tompkins says he doesn't have any complaint about the land, your use of the land, and the use of somebody's property is something that we go to great lengths to protect the use of their property as long as it's not in violation of the regulations of the county. So I'm hopeful that the scenario you're envisioning doesn't happen. If it does, you can come back in and we can talk and see if there's some way of resolving that. But for now, we'll take the chance. I know you don't want to take the chance, but I think it's important that we
I don't know if I have the bandwidth for any more of that,
Okay. All right. So sit tight and we'll give you a copy of this just so you have it for your records. Or you can step back if you're uncomfortable up here. We'll say, Mr. Hall, I've for years gone by that property and I've always noticed how nice the property is kept.
I appreciate that. Mr. Ames did 73 years there, retired in 92, and that was his gem, and the fact that he called me to buy it is huge. It's just such a dichotomy of, reality and fantasy. It's hard.
Yeah, well, I'm always struck. I go by it, fairly frequently.
I saw it for the first time in 94. I had no idea I'd ever owned it.
Yeah. All right. Well,
Thank you.
Yeah.
Thank you.
Okay. Thank you. Brian Brooks, Jeffrey Black. Are you feeding the chickens?
No, feeding the kids. They all wanted quesadillas, so.
Okay. All right. Let's have both of you raise your right hands for me, please. Swear that testimony in this case to be the truth, whole truth, and nothing but the truth.
Yes, Your Honor.
Okay, thank you. All right. So, Mr. Brooks, you and Mr. Black are neighbors?
Correct.
Okay. And you indicated in your petition, I think you said you've been neighbors for 3 years.
Yes.
And you say that Mr. Black screams at you using vulgar language or screams with the children present. He calls you a child molester. He calls police. So tell me, is that an accurate summary of what your issues are?
Yes, Your Honor.
Okay, anything in addition you want to add?
No, sir.
Okay, how often does something like this happen?
Fairly often. I mean, I have 2 younger children, ages 2 and 3, and whenever something doesn't go their way, they voice their opinion by screaming and yelling. You know, they're children. Stop that. For instance, there. And whenever that happens, he always just has to open his door and start screaming.
And he's screaming at you?
He's screaming at me. He's screaming at the children. He screams at my wife.
So I'm assuming the homes are in close proximity?
Yes, Your Honor.
Okay.
He's my direct neighbor.
All right. And have you told Mr. Black that you prefer he not speak with you?
I've been trying to be as neighborly as I can be, but after 3 years of dealing with him, while he does this sort of thing, I finally had enough. And I believe that my children deserve to not have to deal with it.
Okay. Mr. Black,
Yes.
go ahead.
I was a primary caregiver for 3 children. Ages, right now they're actually ages 17, 22, and 27.
Okay.
I've purchased 2 homes. The last one I left to my ex-wife after on top of a broken back I received at 14, I had a bad hernia mesh that left me incapacitated and in the restroom for 10 years.
Okay.
I'm disabled. I do not, I can't get out of the house, I would say, extensively due to pain.
Okay.
Prior to my, again, that was at 30. I had children at 30. Before that, I was a district manager of a clothing store. I trained teenage girls to run $1 million stores. I'm a very apt communicator. I know what is appropriate and I know what is not appropriate. So I will let you know how I met the individual you are speaking to. We live in a cramped trailer park next to IHOP bordering Martin Way. I came home from taking my adolescent child to high school. That's all I do now, by the way. I drive my child to school. That's all I can do. I am Uber for my child while I'm divorced, so I can at least be in close proximity. So I come home. This was the first year upon my arrival. In the documentation, I would like to indicate that trauma is on the list. The first thing, I'm not going to take anything from my experience as much as the documentation. So trauma. And on page 4, the domestic violence and criminal. Jesus said fruits. I think this is the fruits of the condition of the individual I'm speaking to. And so I come home. And when I said, again, I was, so 3 children. The biggest fear of a parent is to lose a child.
Riker.
Go ahead.
Lose a child.
To
have a child die.
I'm a parent, so I understand.
That's you know what I mean? Like that is traumatizing. Would it not be to have that happen to you?
Okay, so
Yeah. Again, no. So I come home, pulling into the driveway. I did not call the police. I see a toddler in their diaper walking towards Martin Way. I stop my car, and it's this child of the individual next to me because I've seen them. Because everybody passes each other outside because you have to because every car's outside, so we can see each other. So I only know them by sight, and I take the child I just said, come on, let's go home. And I walked the child back to the house. And I was traumatized. I was, aghast. And I tried to make light of it. And then the next time I come home, again from driving my child that I cannot be with to school, there was a homeless man with a toddler that is this man's. And I roll my window down and he, in panic, says, do you know who this child belongs to? And I said, yeah, hold on. And I get out and I walk him and the homeless man to him to indicate an obvious inappropriate parental position. And then I told the homeless man, I said, no status of economics will ever there be value to what you have done today. And I'm sorry for your trauma. A homeless man was traumatized. And again, I said, no, I have no anger. I have only sex. I wake up 3 to 4 times a week to this man screaming and cussing and yelling belligerently. And everybody else is Hispanic. And they're across the street. And the person next to him is a bipolar, heavily medicated, recently homeless woman who, again, is a nice lady, but not the best person to, let's say, be a judge of character. So in my day, I have interacted more with the Hispanic population across the street than with him. And then so it got worse. I'm like, how could it get worse? Besides the constants, and they're both this way. So it's not just both, they are constantly. So I did not come from this environment. My parents did not use profanity. Do not cuss. I tell my children, appropriate is based upon position. What? You don't cuss in front of your grandmother. Oh, no. You don't, speak in the same manner with your friends as you do with your mother. Oh, no. That's appropriate wording for the position. Correct? So when I'm establishing I would call it whatever the parameter of this man's verbality of me towards him. Here's this second time. This is the third time. And this is where I had to call. It was the summer last year. I look up and I see 2 naked children on the roof of this man's home. The garbage had gotten so bad in the yard, and the smell was of sewage and raw garbage right next to me. And I wish I was kidding. And it's a box. It's the size of the house. Our houses are small. It's the size of the area you're in right there. And these 2 individuals spend most of their time yelling at each other with 4 children and 2 dogs. And as you know, psychologically, that with the rats in the box, they have a tendency to eat each other. And I am only listening to it and being traumatized and trying not to react, but only when death is. So they're on the roof naked. I can't do anything. They're gleeful, by the way. And I am in horror. I have to go across the street as I'm calling the police to the woman, a woman about my age, to see what I'm seeing while I'm waiting. And I go back in my house because I can't watch it because the kids don't care because they're kids, but they're in, if they fall, they're dead. Okay, so that's trauma 3 for me. Trauma 3. And again, appropriate context. So what trauma is really is, if you've never seen it before, right? I don't know if I'm gonna break the definition. If you've never seen it before, and it scares you to death, that's trauma. Okay. So this happened again 2 times, and I called the police. The DSHS came in the middle of the night. Again, I have to be neighbors here. I am only witnessing this, Your Honor. And there is no appropriate means for me to tell another person to be a decent human being by the means of the law. And I know that. I do know that. That's why I did not become a drug and alcohol counselor. Because I was almost that. So the individuals, I have an accident at the shame level. And that this man was anywhere in his house near his children right now, having the conversation about this as though I'm a threat. So no, and even if the First Amendment laws, like I can have the law, I mean, we can hear each other's conversation. The key to privacy is talking quiet. If I lower my tone, you won't be able to hear me. And I won't be able to know what's going on. And that is gone from them. No, not me, because that has never occurred in the condition. With the witnessing of the abuse that this man has inflicted. And the only time now I had to, because I've never called the police on anybody in my life. Because I have lived indoors where the sound waves of the neighbors never exited to the point where I ever had to hear them, let alone witness abuse daily. And I am traumatized. And I can't have my kids over because it's embarrassing. I sell things on Marketplace. They're screaming at each other while there are people pulling up to buy a doghouse that I make as a hobby to keep my mind sane from witnessing the abuse and the destruction of the souls of 4 children right next to me by a man. And what I would like you to do is to give this parameter to the side. This man is about double me. And cognitively, and this is what I would say, and this is, I do.
Hey, let's wrap it up.
No, hey, and this is what I said. I called my manager of this, and I would just that. So what I would like to do, Your Honor, I do have help in this case for you and in this situation, because I want to leave. I want to get out. I am tired of listening to children's souls die.
All right.
And I would like the court to at least indicate, and I don't know what anybody, because this is why I rode up here and sat here. They're the kids. Because when you are told that you are wrong for pointing at and identifying what is an object,
okay.
And the object, so when somebody is a horrible, evil, vile individual, and then they act like, and then they come up to you and they go, that right after they just turned around, and here's what you get. You get a man doing this, hi, Jeff, how are you? So that's my day, and I'm supposed to just act like whatever they're, punching each other. So,
all right.
Am I done?
Yeah, thank you.
So what I would like to do is if you can at least indicate to the manager, and that would be neat, that Jeff needs to get away from being in that situation.
All right.
So no,
thank you.
And I did not want to be here. And being here for me is trauma.
All right. Try to reduce the trauma here.
So I wait a half an hour, Your Honor, before I call. I listen to a child scream. No, not just one going, not one going, one child screaming miserably for a half an hour straight. Happy beings only need to be encouraged to be happy. I raised 3 of them.
All right.
And the reason why I keep talking is because the voice of the child, I'm a comedian. I've had to write jokes to counter this because there are no pills.
Okay. I can hear it in your voice. I have a lot of experience with
Did I-
children, Mr.
yeah,
Black.
yeah. And again,
I have
they-
children of my own.
they
I have
replaced-
grandchildren of my own.
They replaced
I was
the
one of-
children, when the children were removed, they put a dumpster in next door to me.
I was
I had a
one of five.
dumpster in my parking
All right,
lot
thank you.
to replace the children.
Okay. So, you have every right to call CPS, you have every right to call law enforcement. You don't have a right to engage
Always.
with
Right,
Mr. Brooks.
Mhm.
If he's made very clear he does not want to hear from you.
always.
So, no yelling at him,
No
no yelling
want.
at his children. If you have an issue, you can call the appropriate agencies, and that's your right. But Mr. Brooks has made very clear he does not want you speaking with him or his family members, so you are under order of the court to comply with that. So Mr. Brooks, this order will be in effect for 1 year from today's date. If you need it renewed, you'll have to come back to court and ask for it to be renewed.
Thank you, Your Honor.
Right, you're welcome. You can reach out to the court to get a copy of the order, and we'll provide Mr. Black a copy since he's present here in court.
Thank you, Your Honor.
You're welcome.
So how do you proceed, Your Honor, when you're sitting on top of each other?
You just have to not share any comments. You can call, you can deal with the agencies, but not with Mr. Brooks.
Hey, that's beautiful. I appreciate the fact that that's now going to be a constant. I'll have my video monitoring up constantly now so as to surveil that brand idea.
All right, sorry, we're running a little bit behind on our 9 o'clock docket, but I think to facilitate the jail here, we'll go ahead and take People v. Jeffrey Cortman for sentencing.
Your Honor, for purposes of the courtroom, do you want me to go to the inside and put it on the outside of the?
Sure, does that sound fine? All right, so this is file 25-93381FH for sentencing. Counsel, you want to state your appearances, please? Zachary, I'm applying for the people.
Devin Pomeranke, on behalf of defendant Jeffrey Portman. I am privately retained, not in my DC files.
Okay. And we're here for sentencing on, looks like a charge of possession intent to deliver methamphetamine, habitual third. That's a 40-year maximum. Guidelines were initially scored at 78 to 195. Also, possession with intent to deliver cocaine over 50 grams, habitual third. That's a 40-year max. Those guidelines were scored at 99 to 240. There's also charges of maintaining a drug house, habitual third, 4-year maximum, felon in possession, habitual third, a 10-year maximum, possession intent to deliver oxycodone, habitual third, 40-year maximum, possession intent to deliver hydrocodone, habitual third, 40-year maximum, and maintaining a drug vehicle, habitual third, a 4-year maximum. And Mr. Pomeranke, have you had a chance to review the report and recommendations with your client?
And Your Honor.
Any additions or corrections or modifications to the substantive information in the report?
Just briefly, Your Honor, at the end of, I believe it's page 11, it states, speaks about his son, a statement from his son.
No, hang on, where are you on page 11? I don't see that on page 11.
My apologies, that was. Oh, sorry, that's beginning of page 9. First sentence, spoke to his son, Michael. I would just indicate that Michael is his son's middle name, not his first name, just before any further confusion. It's not a big substantive error. I'm informed that Mr. Portman received his final Social Security 3 minutes that is going to be canceled upon his sentencing to MDOC, and they've been notified.
So do you want the court to direct a change to the son's name on top of page 9?
Yes, just so there's not any confusion.
Right, Sergeant Lesky, can you change that to Stephen Michael? Okay, very good. All right, and you said something about Social Security. What was that?
It indicates he received Social Security and has an income of $75 and up. That was true up until this month. I believe that his final Social Security was received in June and was terminated.
Okay, I mean, it was that statement's accurate. I mean, obviously, he's gonna lose.
Right.
Okay. All right. Any other changes?
No, Your Honor.
Any from the people?
No changes, Your Honor.
Okay, and then there any defense challenges to the guidelines score?
No, Your Honor.
Mr. McLennan, any changes to the guidelines score?
Yes, Your Honor. The only challenge that people would have would be with regard to OV2, offender possessed a pistol at his residence where drugs and narcotics and drug paraphernalia were found. I think that would qualify. It's his residence. Evidence of the crime was found there. There's a charge he pled to for felon in possession of a firearm, and a pistol, I believe, would satisfy 5 points for OB2 possessing a weapon.
So, on which on both guidelines?
Yes, Your Honor.
Well, the well, I guess that might depend upon, do we have a distinction of what's the factual predicate for the possession intent to deliver methamphetamine and the possession intent to deliver 50 grams or more of cocaine? Is that the cocaine found in his car or the cocaine found in his home? Did we make that distinction at the plea taking?
Do not believe we did.
We did, and what was it?
I do not believe we did.
Do not believe we did. Mr. McLennan, what's your knowledge about that? Did you see what I'm saying? If the factual predicate are the drugs he possessed in the home where the gun was, you might have an argument. But if the factual predicate is the drugs in the car, which looks like there was, well, okay, hang on a second.
Yes, Your
For the
Honor.
methamphetamine, it could be either. For the possession intent to deliver more than 50 grams of cocaine, it had to be the home.
Correct.
He didn't have he did have 170 grams in the car. So he had enough powder cocaine. So he had enough in the car to justify both counts. So I guess based upon that, unless there's any information that the charge is based wholly on what was in the home, which I suspect it's not, but then under People v. McGraw, I'm limited to under OV2. That's a McGraw variable, I think. So it's, did he possess the gun while he was possessing the drugs? Without that distinction being made, I would not change the scoring of OV2 at 0. Any other challenges from people?
No other challenges, Your Honor. The only other item that I wanted to bring up was that I believe the sentencing would be discretionary consecutive for counts 10, 11, and 12. Pursuant to MCL 333.7214.
Wait, which counts would be consecutive?
Counts 10, 11, and 12, I believe, would be discretionary consecutive, Your Honor.
To each other?
To count 1 and to each other, yes, Your Honor.
You mean count 4 and each other?
I'm sorry, yes, count 4 and to each other. They are Schedule 1 or 2 narcotics or cocaine, and they are based on possession with intent to deliver.
Mr. Pomeranke, your position with regard to whether any of these charges are discretionary consecutive?
Your Honor, I believe that is.
Counts 10, 11, 12, and 13 do say a consecutive sentence may be imposed for any other felony conviction.
Yes, Your Honor. For the record, Your Honor did make that distinction when we took the plea as well.
What?
Your Honor did make that distinction to us when we took the plea as well.
Oh, okay. So discretionary consecutive sentencing does, in fact, apply. Okay. So Agent Lesky, could we change on page 3 of the CFJ 284? You said prosecutor's office advised that consecutive sentencing was not applied. Indicate that discretionary consecutive sentencing does apply to counts 10, 11, 12. Yeah, just 10, 11, and 12, right?
Yes.
All right. In terms of scoring, I did have a question. OV. Oh, wait, no, I'm sorry. No, I think they are right. I was thinking, I was wondering about OB 12 with contemporaneous felonious acts, but we do have the car and the house. So that would support that OB 12. Is that your understanding then?
Yes, Your Honor. I believe so.
Yeah, Mr. Pomeranke, you don't have any challenge to OV 12. On initial blush, I was thinking maybe that should be 0, because just because he possessed several substances is not separate criminal acts. But we've got what he was possessing in the car and what he's possessing, the drugs and the guns at the home, I think would support OB 12. Do you
Yes,
agree?
Your Honor, in my initial scoring, I also scored 10 for 12.
Okay. Okay, so based upon that, okay, Mr. Pomeranke, go ahead with any argument you wish to make.
Your Honor, I don't have any argument just by way of allocution.
Yes, that's right.
Your Honor, we've in fact been before you before. It is no secret that Mr. Courtman has substantially struggled with a problem with substances. Mr. Courtman, for most of his entire life, worked with his hands, both on trades and on vehicles. At this later part in his life, he has become more bound to his chair and limited by his mobility, his energy, and everything else. That's the premise and excuse that he used for himself to continue using and to support his habits, and the urge and the need to do that in order to get what he thought was justifiably more things done. Mr. Courtman has since ran out of road. In that regard, he needed, he thought this was a way, I think, to sustain himself or support himself. And well, he was caught. He understands the gravity of this, and he accepts that he's made a substantial mistake. With that, Your Honor, there's not much more I can say besides my last point. Mr. Courtman sits before you, a very fragile man. He sits before you, a fragile man. The guidelines that we have before us today are substantial for anybody, but especially somebody with potentially limited time, somebody who is sustaining some pretty serious health things in the last few years and has some more to look forward to. I understand that the court has the ability to, and the discretion to impose consecutive sentencing. I
don't think I'm going to do that. I think I'm going to do concurrent sentencing. If the prosecutor persuades me otherwise, I'll give you some rebuttal time. But this is just a bunch of drugs in the car and in the home. I'm not sure that there's aggravating circumstances beyond that. The fact that it was just the amount and the different substances that would warrant the imposition of consecutive sentencing.
Thank you, Your Honor. That saves me some time and you some time. With that, Your Honor, I would just ask that the court consider the low end of the guidelines, which is still a substantial amount of time for somebody with potentially limited time.
Okay, thank you. Mr. Cortman, you don't have to say anything to me today, but you're welcome to. Is there anything you want to say today, sir?
No, sir.
Okay. Mr. McClellan, recommendations from the
Yes, thank you, Your Honor. Defendant is 64 years old. He has 5 prior felonies, 6 misdemeanors, 9th grade education. We're here today, Your Honor, obviously for, you said there was a lot of drugs found in his car and his home. I note in his criminal history, it wasn't too long ago that he was before you for similar charges in Sheboygan County. Looks like there was delivery charges there, firearm charges as well. So here we are today, 5 years later, and we're seeing more of the same, but I think that this one is more serious, Your Honor, both in terms of repeating the offense and in terms of quantity of drugs found. In my discussions with Hunt, I've been told that this is among the largest, if not the largest, drug bust in Prescott history. And defendant made the choices. He made the choice to go downstate and get these drugs. He made the choice to bring them up into our community, into our county, and then further distribute the drugs in our county. And it's an offense, Your Honor, I would submit that isn't just ending at the handing off of the drugs to someone else. You're profiting off the pain of the addictions of others. And I believe then the downstream effects of drugs in our community are horrendous. Increased crime, the impact it has on families, probably the economic impact it has on our community. So I think there's a lot of ancillary effects to drug crimes, and especially when it's at this quantity. I don't think he learned his lesson. Obviously, he did not learn his lesson in 2021 in Sheboygan, and he's amped things up since then. I think the guidelines really do reflect the seriousness and the impact of the crime here, Your Honor. I'm seeing 99 months on the low end. I don't think that properly accounts for what's happened here and what has been happening. I think that 15 years, 20 years is a more appropriate number, Your Honor. And that's within the guidelines as I understand them to be. Your Honor, based on all of this and the repeat nature of the offense and the impact it has, which I submit is tremendous, I would ask the court to fashion a sentence somewhere between 15 to 20 years. Thank you, Your Honor.
Thank you. All right, well, this case involves several serious charges with significant guidelines, ranges, discretionary consecutive sentencing. This case involves the defendant making essentially drug runs downstate for further trafficking, not just that he's going down. We see a lot of times somebody with their own drug problem going downstate, buying some drugs for themselves and a little bit more to boot so that they can sell it to some other friends to continue to support their cycle of use. Those are deliveries, but they're not, they're not really trafficking deliveries. This did involve significant quantities found in Mr. Cortman's vehicle and in his home. Methamphetamine, cocaine, both powder and crack, and various pills. And there's evidence that he was selling that to other people who would in turn sell it to others. So Mr. Cortman was pretty significantly involved in drug trafficking in our community of some very harmful substances that really destroy lives and families. And I had him in 2021 in a Sheboygan drug case, not as serious as this, and I gave him 6 months in jail. I had him in 2022 in Prescott County on a drug case, again, not nearly as significant as this, but again, I only gave him 6 months in jail. So, I guess folks listening to that would be perhaps justified in thinking, well, gee, shame on the judge, 6 months didn't do the trick. trying to give people every opportunity to make changes and better themselves. And Mr. Cortman didn't take those opportunities, but really kind of doubled down on his involvement in the drug trade. Also, he's got a loaded pistol at his home. Some counts have discretionary consecutive sentencing. As I mentioned here, I would impose concurrent sentencing for the reason that there's no aggravating factors between the counts themselves, but merely a function of the fact that there were different controlled substances. So I don't think that's the kind of situation that calls for consecutive sentence. But for all these reasons, I believe that the guidelines do adequately take into account the seriousness of the circumstances of this offense and this offender. However, his repeated pattern of drug crimes in the 2020s here does not call for a low end of the guideline sentence. I believe that a proportionate sentence, in addition to the standard fines and costs, would be a sentence at about the 2/3 mark of those advisory guidelines. So for those reasons, this is my sentence, Mr. Cortman. On count 4, possession with intent to deliver methamphetamine, habitual third, with a guidelines range of 78 to 195 months advisory. I'm going to commit you to the Michigan Department of Corrections for a term of not less than 13 years, nor more than 40 years, exercising my discretion to increase the statutory maximum under the habitual statute. Give you credit for 381 days previously served. There is fines and costs, $468 in state costs, $130 in crime victims assessment, $350 in court costs. As to count 5, maintaining a drug house habitual third, going to commit you to the Michigan Department of Corrections for a term of not less than 2 years, nor more than 4 years, increasing the statutory maximum under the habitual statute in my discretion, with credit again for 381 days served. Count 6, felon in possession of firearm habitual third, commit you to the Michigan Department of Corrections for a term of not less than 5 years, no more than 10 years. Again, using my discretion to increase the habitual statutory maximum. Again, credit for 381 days served. Count 10, possession with intent to deliver more than 50 grams of cocaine habitual third. Going to sentence you at the 2/3 mark of the guidelines to 16 years in prison or 193 months. $16 years to 40 years, credit for 381 days served, increasing the statutory maximum from 20 to 40 under the habitual third statute. Count 11, possession intent to deliver oxycodone habitual third, commit you to prison for 10 years to 40 years. Again, discretionary increase of the statutory maximum for the habitual, credit for 381 days served. Count 12, possession intent to deliver hydrocodone habitual third, prison 10 years to 40 years. Again, increasing the habitual, under the habitual statute, the statutory maximum, and credit for 381 days served. Count 13, maintaining a drug vehicle habitual third, prison 2 years to 4 years, with the habitual third increasing the statutory maximum of my discretion, and credit for 381 days served. So the operative sentence, those are all concurrent. So, Mr. Cortman, the operative sentence is the 16 to 40 years in prison. That is at the 2/3 point in the guidelines, I believe, for the reasons I've stated, that is a proportionate sentence to the circumstances of this offense and this offender. Mr. Cortman, if you want to appeal, you can file an application to the Court of Appeals. If you wanted, if you wanted a lawyer appointed to you, you'd have to make that request within 6 months. We're going to hand you a piece of paper explaining those appeal rights. And ask you to initial one copy for it. The other one is for you to fill out if you want to take an appeal. Anything further from the people?
No, Your Honor.
Anything further from the defense?
No, Your Honor.
People be Leonard Randall. You sentence him? This is file 26-93402FH. Counsel, you want to state your appearances for the record, please, for the people?
Jeremiah Buffalo, work on behalf of people.
Thank you. I'm Miranda Bainbridge on behalf of Leonard Randall, who's present tonight.
Okay, good morning. This is the time and date set for a charge of attempted felonious assault, high court misdemeanor with a maximum of 2 years prison. There's a guideline range of 0 to 1 with a sentence agreement for a 6 to 12 month delay with a reduction to misdemeanor assault. Counsel, have you had a chance to review that report and recommendations with your client?
I have.
And do you have any additions or corrections?
I do have a couple, Your Honor. And perhaps the first one is just simply an inquiry as to what is characterized as drug abuse history on the basic information report and in a couple other locations that indicates that Mr. Randall has a substance abuse history. And although he identified using marijuana, a couple of hits at night for the last several years, there's no other history of any sort. And so I guess I just had a little bit of an inquiry as to whether or not that's what's characterized as a drug abuse history or if that could be modified.
Yeah, I mean, that's just under substance use history. He self-reported using marijuana 5 to 6 times a week, not for medical reasons. So that's all accurate in there. And I think I suppose then indicating substance abuse history on the cover sheet is consistent with that. It's certainly not the most extreme,
All right. And then on the PSI itself, under personal history, it says alcohol. How long? 2005 to 10 of 2004. That should be 2024.
Oh, okay. So Agent Lesky on page 1 of CFJ 145 and on page 6 of the CFJ 284, the alcohol use, can you change that from 2004 to 2024?
Yes. And then similarly on page 6, under mental health, it identifies a treatment begin date of February of 2005, and that should be February of 2025.
Oh, yeah. And in the narrative, it does say 2025. So Agent Lesky, can you change the typo in the box to 2025? And Ms. Bailey, quick, I know I don't have a whole lot of criminal cases with you. I know Agent Lesky is a very diligent agent. If you just call her ahead of time with typographical things, she'll just make those changes without us having to go through it in court time.
Okay. Thank you.
Just for future.
Yeah. And I know over the holiday, and there was some difficulty.
Good. Go ahead. I'm just saying for future reference, you can just take care of that.
Very good. Thank you. I believe that was it. It is.
The guidelines scored at 0 to 1. Any scoring challenges?
No challenges.
Mr. Wirgo, any additions, corrections, or scoring challenges?
No, Your Honor.
Okay, I only had to say that to you because I gave the prosecutor grief about all the typo changes a few months ago. And
Gotcha.
do those off the record. So what's good for the goose is good for the gander. All right, Ms. Bailey, quick, anything you want to say in behalf of your client?
Yes, Your Honor. This was it. I trust and believe the court reviewed the PSI thoroughly. This was a unfortunate circumstance or ending to a marriage ending and a new partner being involved in over the course of essentially 2 years. That was also part of the original reason why not solely, but part of the reason why the marriage had ended. And there had been, and I think this is important to identify for the court, is that the parties, pursuant to their judgment of divorce, utilized apt close for communications. And there was a circumstance shortly before this incident occurred, back in March, I believe it was, that Mr. Ortiz and Miss Randall at the time appeared and showed up at the house where Mr. Randall was continuing to live. And there was a request that she give notice to Mr. Randall if she was going to be there, and that he was asking that Mr. Ortiz not be at the property until he vacated the property. notice wasn't given that day. So when he heard them, it did come as a surprise. And so, he recognizes and acknowledges his inappropriate actions on that day and completely understands that he should have and could have handled that differently. But I do want the court to understand that this was a circumstance where it was really 2 years leading up to this. And as much as I said it was unfortunate, I think it also was fortunate in a way, because it was a complete eye opener for my client and how he should be handling himself and how he should, conduct himself around Mr. Ortiz. He's a dedicated father and an active and involved father, and he understands what and how he could have jeopardized a lot of aspects of his life by result of what he did on that day. He was in the process of cutting bread and still had the knife in his hand, although even Mr. Ortiz identified that he didn't raise it or threaten him with the knife in his hand in any way. Mr. Randall, I believe, acknowledged that he didn't even realize he still had the knife in his hand when he went out to that room, but that he never raised his hand or threatened Mr. Ortiz with it in any way. But in any event, he still should never put hands on Mr. Ortiz. And he knows that, and he acknowledges that. And so I did receive a copy, and I reviewed the victim impact statement with Mr. Randall. And I don't want the court to view anything that I'm going to say about that victim impact statement negatively toward Mr. Randall in any way. But the only thing I'm going to say is there's a lot of history in there that is viewed, I think, strictly from Mr. Ortiz's standpoint. And my client has a lot of exceptions to what was said in that report, and his recollection and participation in prior events leading up to April of this year was different. And so I think that's fair and that we see that in many cases. But I don't want to get into argument over what happened on that particular incident, as it really doesn't impact what the incident was on the day in question. And so I don't want the court to, by me arguing about those prior incidences included in the victim impact statement, don't want the court to view that as taking away from Mr. Randall's acknowledgement of his improper acts in April of 2026 and his remorse for it. So that, I mean, for the most part is, we're just asking the court to follow the sentence agreement and the plea. Mr. Randall's 46 years old. He's never been before the court. This was, as I indicated, a complete eye opener for him and nothing he wants to experience again. And he's been working diligently with his counselor on how to handle certain incidences and behaviors and in ways that if they were to occur in the future, how he could address those in a completely different manner than how he did in April of 2026.
Okay, thank you, Ms. Bailey. Mr. Randall, you don't have to say anything today, but you're welcome to. Is there anything you want to tell me, sir, or no?
I just want to acknowledge that my behavior on that morning was not of my character, and I regret my actions of that day. I am, Miss Bailey said, I'm 47 years old. I've never been put in handcuffs. I've never been put in the back of his car. I've never spent time in jail. That was extremely humbling to me, sir. The consequences of my actions that day, I realized, could be far-reaching. Not only for my personal freedom, my children, my work, my other relationships, and I regret that I have to be here today due to my inappropriate actions.
Okay, thank you, sir. All right, Mr. Wirgo, any recommendations from the people?
Begging the court's pardon, Your Honor, I would ask that the court include the victim impact statement within the PSI. When I got them, they were bundled together. I thought it was part of them, but I do think it would be appropriate that the PSI actually include that.
Sure, and I have had a chance to review that, and Agent Lesky, if you can make sure that that's attached to or included in the PSI.
And then, Your Honor, I do believe we do have a victim that would like to speak.
Yes,
Yes,
sir. You want to come on up forward at all?
Yes, sir. Do I need to identify myself?
If you wish. If you don't wish to, don't.
My name is Pablo Fortes II. I'm a master instructor at Straits Area Taekwondo Academy, and I'm a Marine Corps veteran.
I have had a chance to review your written statement or a typed up statement from your previous statement as well. I just want to let you know I've read that. Go ahead.
And the things that I've heard sound nice. They also sound like things that should have been thought of before hands were placed on me. Privilege is assaulting someone and getting fines and probation. Privilege is having your accounts of events unquestionably accepted, despite evidence to the contrary. Privilege is terrorizing children and women, yet crying out as the victim. Privilege is premeditation of a crime, but not being charged with it, like disabling cameras set up to prevent specific actions that happened. And then not being charged. Mr. Randall is blatantly on record with the internet service provider as giving himself privileges, administrative privileges, 2 cameras that were set up to prevent him from acting like that. He disabled those cameras 1 week prior to the assault, coincidentally. And I would like those things to be reflected here today. You trashed your relationships and blame me for loving people that you discarded. You want to pretend like grace isn't a factor. However, you were certain another veteran and instructor was making you a cuckold. And you did not assault them. You were convinced beyond a shadow of a doubt that other martial artists were making you a cuckold. And not once did you step to any of them. But of course, all of those men are Caucasian. So that needs to be overlooked, right? That glaring incongruence. Your willingness to sleep with brown people is not the shield that you think it is. My children have been afraid of you since you started coming to Taekwondo events and staring at me. Approximately 2 years now. For 2 years, I've had to explain why you act just like the racists that they're used to. You are no small part as to why my children struggle to accept their Caucasian heritage. And it was men like you that made it difficult to accept my own European ancestry as a child. You are not a man. You are man-shaped. You are an 8-year-old's idea of what a man is. And you are exactly like your father. How, sir, did it feel to give another man your best shot only to receive a blank stare in return? Armed with the knowledge that you received when you put your pathetic hands on me, know this: you will never step foot on my property again. You will never yell at Kate again. And you will never get in my face again. This, what happens here today, is your white privilege bye. Because only white privilege allows you to do the things that you did and rewards you with a slap on the wrist. You never served this country. You are not serving this community, and yet every privilege under the sun has been set at your feet. If that is not a glaring example of white privilege, sir, I don't know what is. You attacked a self-defense instructor, and you're being rewarded. I'm trying to move on with my life. I'm supporting my partner and my stepchildren. And yet, even pre-sentencing, you still continue to orchestrate opportunities to stare and sneer at me in public, just like you did at the Independence Day parade. You caused my work performance to suffer by your constant harassment. You negatively impacted Kate's work day, the day of the assault, in her workspace. Everywhere I go, I have to make sure you'll be on the right camera angle when you show up. And so far you have been. Walmart security has a special file just for you. Your conduct leading up to you assaulting me has earned you a ban from Straits Area Taekwondo Academy's UP location and Sheboygan location, a ban from Lacrosse Martial Arts in Alpena, a ban from Black Dragon Martial Arts and Wellness Center in Sault Ste. Marie, and a ban from all Rudyard area schools properties. You have been banned from all Northern Michigan Martial Arts Alliance tournaments and events. This is not my doing. This is the direct result of your conduct, that you don't want to be included into this as to you assaulting me. This is pertinent context. I did not give you these bans. You earned them with your conduct, the way that you acted in front of children and the public. So what I request of this court is you make a different type of example out of him, not one of privilege that he's all keyed up for. And to his defense about being stranded during the snowstorm, there's no point. You did wrong. And when you do wrong, so there's supposed to be consequences. That has not been my experience up to this 40th year. But I don't live in the North anymore. I don't live in good old boy towns. I specifically moved here to get away from that type of stuff. So whatever the court does for you or to you, there has been a clear pattern. And I'm done.
Okay, thank you, sir. Mr. Wirgo, any recommendations from people?
Your Honor, I do believe probation did a great job on the PSI. We've asked the people the recommendation.
All right, thank you. Mr. Randall, would you please stand with your attorney for the decision court sentence? Mr. Randall, you're in your mid-40s, no prior criminal record. In this case, you know, you were, I mean, both the victim and yourself recognize you were in the wrong. You know, you've admitted as much, and you committed an assault, and you did that while you're holding the knife. You didn't use the knife in the assault. Holding it. It's a really dangerous situation, right? And if you're Mr. Ortiz on the receiving end of that, he doesn't know what you're planning with that, and that could have so easily escalated to, a terrible event. And, I understand there's some context here of a relationship that Mr. Ortiz has with your ex, and Mr. Ortiz, I assure you, sir, Mr. Randall's race has exactly 0% to do with the sentence that I'm imposing today. We treat first-time offenders differently, whatever race they are. And, I don't know all of the history of the context between Mr. Randall and Mr. Ortiz, but it's not a blank slate. There's some, it's a story as old as man. 2 men and 1 woman. And, that doesn't make any of your actions right, Mr. Randall. You're the one that's 100% in the wrong. But just that the fact that Mr. Randall is receiving a delay today is a function of several things. His age and complete lack of criminal record, the lack really of any severe criminogenic needs. There's a risk and needs assessment that's evidence-based that the Michigan Department of Corrections conducts in these cases. And, he's a low-risk offender for further offenses. He's going to be engaging with or continuing with treatment services to make sure that he addresses the reasons why he acted in the way he did so that he doesn't in the future. And those are all appropriate. So for those reasons, I'm going to follow the plea agreement and the recommendations with a little bit of a change. I do think this was a very serious event because you're holding the knife. So I'm going to order a full 12 months on the delay, but I will place you on a delay of sentence for 12 months, subject to the terms and conditions listed in the pre-sentence report on pages 2 to 3. Those include no contact with Mr. Ortiz. They include maintaining legitimate employment, crime victims assessment of $130, monthly supervision fee, court costs of $350, DNA testing with a $60 fee and $68 in state costs. And you do have to continue the counseling program under the guidance of your supervising agent. Now, Mr. Randall, what we're doing legally is delaying your sentence for a year to see if you warrant leniency from the court. If you, at the end of that year period, have complied with everything, we're going to come back for a sentencing where the charge will be reduced to a misdemeanor assault. At that time, I can still consider whether jail or probation is an appropriate response. The felony or high court misdemeanor will have gone with. If you violate the terms of this delay, you'll come back for a sentencing on the attempted high court misdemeanor. And that would be a bad day for you, right? All right, so you've got a year to show me that this plan is a good plan. And because of that, we're delaying the sentence. There's no appeal rights at this time, and you're not eligible for any early discharge. We'll set it for a sentencing in about a year.
Connor, I do have one question. As part of the conditions 4.5 is no contact with Mr. Ortiz directly or indirectly. It must not be within 500 feet of their residence, school, or place of employment. Mr. Randall has been very good about communicating with his ex-wife where he's going to be at with the children. For example, the 4th of July parade, where exactly they would be, so that there was no contact between him and Mr. Ortiz. And likewise, he's asked that Mr. Ortiz not come to parenting time exchanges, and yet Mr. Ortiz is still showing up for parenting time exchanges, and that causes him concerns as far as the prohibition. And these are exchanges where my client simply picks the children up. He parks at the end of the road, the driveway, and the children come out. He doesn't even go in the driveway. But the other occasions are when Mr. Ortiz is coming to his house.
Well, I mean, I'm not going to police the exchange points in a family law case, and you're an experienced practitioner in that area. Maybe they should pick a different exchange, but Mr. Ortiz is under no orders from this court. Your client is. So I guess, you can help him navigate that in the best way possible and maybe change an exchange point in the family law case.
Okay, all right. Thank you.
All right. Great. And then let's call sentencing to be Wyatt Chapman.
Good morning, Your Honor. Luke Kuski on behalf of Mr. Chapman.
This is file 25-93379 after who's for the people on this file?
Before we get too far in, I just want to warn everybody, this is the last case of the evening, and it involves one of the most depraved acts a human could commit with a pet. It's crazy. So this is your trigger warning, if you need it. If you don't, stay tuned. This gets weird. And trust me, you want to see how this ends. Back to the program.
Okay, all right, and this is a sentencing on a charge of animal torture, 4-year felony. The advisory guidelines were scored at 10 to 23 months. I have had a chance to review the pre-sentence report as well as a couple of support letters for Mr. Chapman. Mr. Kessler, have you had a chance to review the report and recommendations with your client?
I have, Your Honor.
Any additions or corrections to the factual information?
We did not have any additions, corrections to the fact goal.
Any scoring challenges?
There are no scoring challenges.
Mr. McLennan, any additions, corrections, or scoring challenges from?
Nothing further, Your Honor.
All right, thank you. Any scoring challenges from the people?
No, Your Honor.
All right. All right, Mr. Kukuski, anything you want to say on behalf of your?
Thank you, Your Honor. Mr. Chapman stands before the court for sentencing today, and as Your Honor understands, of the animal cruelty. He's been, and the conduct in this case is alleged almost 2 years ago. Since that time, Mr. Chapman has been counseling with Thunder Bay. He's also been seeing community mental health as well. As the PSI notes in his history, he's dealt with a lot of trauma, Your Honor, as a child, and then at the hands of individuals that he was just associated with in his drug abuse in the past that he's had, that have really been challenging, and he's been really trying to overcome that abuse and that drug use and that past, Your Honor. And I think it's important to note that the bond in this case has been going on for over a year, and he's been compliant with that. We haven't had any issues. I haven't had any show causes or brought before the court for any issues since I've handled the matter, taken on this matter. So he's made those changes in his life. He's surrounded by an extremely supportive family, his father and his mother. He's actually, since he's moved back from Texas, where he was in an abusive relationship, he's got some time to parent with his son, which has been a real eye-opener to him. As Your Honor had stated earlier, the older you get, the more it seems that you just can't break those habits or make those changes in life. And White's still a young man, and he's still making those changes and pursuing that better lifestyle, a better father, better son, and just a better member of the community that he lives in. He's been working with his uncle, I believe, at a lodge where he does maintenance. He cleans at the lodge. He does have a daughter that he supports. He has I guess not a biological daughter, but another daughter that father passed away, and he stepped into that role as a father figure. He has not seen his daughter in some time, but he and his son, he's making efforts at paying the child support. He is in arrearage, but he is making payments on that because that is important to him, and he understands that. Your Honor, he's just no longer the man that he is or that he was back when this report was I guess made, and the allegation that the conduct was made. Your Honor, I think he's really taken a step forward, been remorseful for his conduct, as I said, and as the PSI also indicates, he last time he was in prison or incarcerated to prison, he was diagnosed with PTS and several other mental health issues that he's been working through, and a lot of that stems from that past and that abuse that he had suffered. And he's not making any excuses. I'm not making any excuses for him, but I think when we're looking at somebody, and I understand a prosecutor's position, and he has not been successful, and PSI has probably noted this on probation in the past, and that's why they're recommending a straight incarceration sentence. We do feel the sentence is appropriate to just keep him to the limited to the county jail. We don't think prison would benefit him in any way. I just think he'd get back into the same routine, or back to being exposed to the same types of people in garbage that's there. If he could maintain, and we didn't even ask for probation, Your Honor, as a way of monitoring. I understand that has been given to him in the past, and it has not been successful in the past. But Mr. Chapman would really like the opportunity to show that he is a changed man, and that he's making the efforts to move forward in a positive manner in this case. And for that, Your Honor, we think the recommendation is appropriate as it is. We would ask, and if the court is willing to go with the county jail recommendation, that if the court does see that probation might help him or encourage him or keep him on the path that he is on, a sober path, a treating path with his mental health, and just moving forward with his life in a positive manner, positive direction. This young man can make a change, and he has, and he's trying to. We'd ask the court to order some probation in this matter. I appreciate the court for its time. Thank you.
All right, Mr. Chapman, you don't have to make a statement today, but it's allowed. Is there anything you want to say or no? Yes, Herman. Go ahead and stand.
I apologize if this comes out scrambled. I've been working on a statement for a long time, and
decided not to send it in because I don't want to sound like I'm trying to point fingers with maybe somebody else guilty for my actions at all. But basically, I stopped all my addictions actively. Gambling, I stopped gambling, methamphetamine. It was a really big problem for me, and it really messed my brain up. And I wasn't in the right mind for a while, a couple of years. And I've been able to stop all my addictions. I'm actively staying sober every day. And I've come a long way because it's been a long road, obviously. And I haven't seen my kids. I hadn't seen my kids I had 3, and I haven't seen them in over a year. And I finally got my son back in my life because I'm sober and doing good. My parents see how good I'm doing. My son's grandma sees, and she's agreed to let me see him. So I've got to spend, a couple months with him now. I'm kind of on and off. And I'm willing to do anything I have to do to just change at this point. None of the who was involved and who said what and what really happened, none of it matters. Just I did go through a lot of physical, mental, psychological, sexual abuse, and when I was in Texas, and it did kind of just lead right up to me being here today. Obviously, I'm the one responsible. I'm working for my uncle, like he said, $20 an hour. He's just helping me out as much as he can, and I just really want to be here for my son. He's still getting to the age where he's starting to realize, we're telling him the truth about everything, and not everything, but he's starting to realize, like my dad's messing up, and my dad's hasn't been here, and my dad's whatever, and I see it. And today I left him on the couch, and he was crying, his face down in the pillow, and I was in a rush. I had to leave. I'm sorry, buddy, I gotta go. And call me, write me, and it just kills me seeing him like that and having to have them go through anything. And it would I really hope none of them ever found out about any of this. So apologize. I just want you to know that I'm doing better and I'm finally in a good headspace. It's been a long road, and I've rid myself of toxic people. I don't associate with anyone who is in my family. And I just feel like I'm taking a step forward, like 2 steps back right now. And I just don't know what's going to happen to me in there. And get scared, obviously. And because it's been an uproar. This whole thing caused this, kind of a big deal. And I've had people harassing me, and I've been threatened. And I just would beg today for your mercy and understanding in this matter, and some leniency, if possible, if appropriate. And I apologize again for the speech not coming out great, but I did work on it for a long time and just decided to leave out all of everything else because I'm here today, and that's that. So I apologize to everyone that had to even hear about this, and I hope that nobody would end up being in the same situation I am right now, because it's not fun. And I tried to commit suicide when I was in Cadillac jail last year for the first time ever, my first attempt, and pick a safety razor and disassembled it. And they caught me in the shower just in time. And they said at the hospital, you lost almost all your blood, and you got your rest of time. It's like, okay. And I chased away those thoughts, and I realized I gotta live for my kids. Like they need me. My daughter's miserable right now with their mother, and I just want to get in a position where I can get them back in my life for good. I apologize. That's all I have to say. I'm just deeply remorseful. Yeah, thank you, Mr. Chad. Mr. McFarland, any recommendations from you?
Yes, Your Honor. Defendant is 31 years old. He has 6 prior felonies, 6 misdemeanors, and a GED. And when I think about this case, this defendant, Your Honor, and I try to zoom out, obviously he is a young man. If you look back at his criminal history and involvement with the court system, It is quite consistent, and it has just not been, it has not been exemplar by any stretch of the imagination. And it's really been a very poor record of performance when he has been given opportunities on probation. As I sit here today, Your Honor, I would maintain that he would not be a good candidate for probation. I do appreciate what Mr. Chapman is saying, and I particularly appreciate his comments about his children. And I noted down, he says, you got to live for your kids. You do. You got to live for your kids. And making these choices is not going to cut it. They are choices. And I want to echo something Mr. Husby said as well, that Mr. Chapman's done fairly well on bond. He has actually, compared to at least his probation history. And so, Your Honor, but when I put it into context, it's almost like the tip of the iceberg, and there's too much of a pattern and track record in the past to overlook. I would maintain he's a poor candidate for probation, given his criminal history and past sentencings, Your Honor. I do think that a term of prison would be appropriate under the circumstances. And I would ask Your Honor to impose such a sentence. Thank you.
Thank you. Mr. Chapman, if you please stand for your sentence. You're 31 years of age. You have 6 prior felonies and 6 prior misdemeanors. We're here for sentencing on a charge of animal torture, pled down from a charge of sodomy for you having sex with that animal. You know, everybody's talking around that today, and you're shaking your head. That's what you're here for today. I don't know who else you're talking about, who else you would blame. I don't know who else you could blame. Not the dog. That is extraordinarily deviant human sexual behavior. These text messages would turn anybody's stomach reading them. I'm not going to read them on the record today. So I thought, gee, you know, been a judge for a while. I've been involved in the criminal justice system. I don't have a whole lot of experience with bestiality cases. What are we supposed to do with those? It's a 15-year felony. You pled down to a 4-year felony. You do have, with your prior record, could have been habitual. So I thought, well, gee, how should I think about this crime? Other than with, you know, the obvious disgust, how should I think about it in terms of an appropriate and proportionate criminal justice response? So I tried to find out, like, well, okay, I haven't sentenced anyone for this crime. What have people who have sentenced people for this crime done? There's a published case, People v. Haynes, out of Calhoun County, 281 Mishat 27 in 2008, where somebody with a habitual 4th record got 30 months to 20 years in prison for this crime. Now, that was the only reported case I found. I did find some media reports that in 2011 in Clinton County, somebody was reduced to a misdemeanor, so they didn't get much jail. In 2013 in Muskegon, a judge exceeded the guidelines and gave prison. In 2019, an MSU physicist pled down to a misdemeanor. So again, when the prosecutor pleads it down to misdemeanor, there's not much that happens. And then in 2024 in Bay County, the judge exceeded the recommended sentence, but I couldn't see what the sentence actually was. So sometimes, you know, prosecutors plead it down to a 90 or 93-day misdemeanor, but when they don't, it seems like judges in the state of Michigan have sentenced it pretty strongly. So then I thought, well, what should I think about this behavior from a criminal justice response? And I did find a couple interesting articles from the Journal of the American Academy of Psychiatry and the Law. Volume 42, number 4, an article, Zoophilia and the Law, Legal Responses to a Rare Paraphilia. Notes that research suggests that those who engage in zoophilic acts are at heightened risk of sexual offending against humans. The same journal, volume 47, number 3, Arrest and Prosecution of Animal Sexual Abuse Bestiality Offenders in the United States, 1975 to 2015. That was a very enlightening article. It notes in at least 3 studies, sexual offending against animals has been associated with human sexual offending. You know, I think which seems consistent with ordinary common sense that someone who's engaging in just such severely deviant human sexual behavior with animals would be just somebody we'd be really worried about. So I am. And you come to the court with a straddle cell guidelines, prior poor history on supervision, including parole, 6 prior felonies. And these guidelines, you know, that they're so high because of your prior record. The offense variables are 0 points, no aggravating circumstances at all. You know why? Because we don't write sentencing guidelines with in mind people having sex with animals. When all the smart folks in the state get together and they come up with what are our sentencing guidelines, they don't build in a variable for what do you do when you have sex with an animal. Right? So those guidelines don't take into account the extremely deviant behavior. They don't take into account the risk of harm that you present to the community as suggested by the scientific or psychiatric literature. They don't take into account that you pled down from a 15-year felony with an habitual. And they don't take into account that you had a previous animal cruelty case that seems to be connected with this deviancy as well. You bought a dog that didn't do what you wanted, so you abandoned it. And then you found a dog that did do what you wanted. The guidelines don't take that into account. And I think on a charge of animal torture, I honestly think the maximum sentence that I can give you is 2/3 of the minimum, the so-called Tanner max. And honestly, with your prior record and the concerns that I have about this deviant behavior, that's appropriate. That's the sentence. So there's crime victims assessment of $130, $68 in state costs, $350 in court costs. I'm going to commit you to the Michigan Department of Corrections for a term of not less than 32 months, nor more than 4 years. Give you credit for 126 days that you've previously served. You can file an appeal if you wish by filing an application. If you want a lawyer appointed, we have to make months. We're going to hand you a couple pieces of paper about that, ask you to initial one, and then the other one is for you to fill out if you want to take an appeal. Yes, Mr. Chapman?
Can I speak one more time?
Well, I've announced my sentence, so no. If you have a question, I'll answer it. But your opportunity to allocute was already made, and I've announced the sentence. You can appeal if you wish.
Okay. Can I ask a question, Your Honor?
Yes.
So, there was a lot of things I didn't include at all, just because.
That's fine. That time is passed. That time is passed. You're in custody. Go with the deputies immediately.
My question was.
Go with them immediately. You're not asking a question. You're telling me other stuff. Go.
The question was, why have I never been charged with anything like
Go
that
ahead.
before?
Go ahead. You can appeal it.
$32 months minimum, 4 years maximum. Oh my God. I'm sure if the judge could have given him more, the judge probably would have given him more. I believe that was probably the top level, probably the tippity top, the max that he could get. I wasn't going to show that one, but it was so interesting. I have to admit, we don't ever see cases like that. At least not specifically like that. Oh my goodness. I wish the prosecutors would not drop charges down for things like that. And the case right before that one, where we had the martial arts instructor who was just so sure of himself that, you know, that guy was getting out of justice simply because he was a white guy, and that made all the sense in the world. It had absolutely nothing to do with the fact the guy had no criminal record at all. See, and you see, that's the two differences between no criminal record at all and a massive criminal record and having sex with a dog. Come on. Oh my God. I can't believe I didn't have to say that out loud. Oh, it's been a crazy night all the way around. The Thurston cases were kind of nuts. Yeah, once that guy started talking in the second Thurston case, I knew the train had completely derailed and we were not making it to the station. Judge Buckley was done before that guy was halfway finished. And the guy with Judge Hesselink who thought that he could just buy a truck and keep it without paying for it. He owed like $8,000 for repairs on the truck that the lady bought for $5,000. Now he's giving the truck back. He's still got to pay that $8,000 repair bill. That lady's going to lose that truck to the repair shop. You know she is. You know how that's going. Ladies and gentlemen, Same Wolf time, Same Wolf channel. Tomorrow we will have a lot more cases. This weekend, this Friday and Saturday, I have a special set of cases that we're going to watch with Judge West. It is a full trial with Judge West, and it's very interesting. We're gonna start Friday night. We're gonna watch all of it, and then we'll watch another part of it, another 3 hours of it on Saturday during the day, and then we're going to watch the end of it Saturday night together, ladies and gentlemen. And we're going to be live for every single one of those presentations. No premiere on Saturday night. We are live. That is the decision I have made, and that is the proclamation I am sticking with for now, until I change my mind, which could happen in the middle of the week. Yep. That's how it goes, ladies and gentlemen. I am your Lone Wolf Uso. I am your humble host for these here little get-togethers. I'm the guy who finds these videos, and I put them together in these little compilations, and we all sit around and talk about it and chat. And chat's amazing. Oh, God. I didn't say thank you to anybody. I didn't play credits. I'm going to do all of that right now. Thank you, Specs. Thank you, Nina out of the blue. Thank you, Darth Steven. Thank you, Specs again. Thank you, Specs again. Thank you, Barry Adams. Oh my God, I suck at this. Oh yeah, Jason and Joseph and that mysterious Jacob person. Thank you all for coming out and hanging out with us tonight. That was really cool. Wow. That's really embarrassing.
And remember, only you can take a bite out of crime.
Bye. And I have a special request from the chat that we not have any more animal abuse cases for a very long time. And I do promise that I am not going to have any more abuse cases of any sort. I just don't like those as a general rule. We can have good court cases without having cases about horrible things all the time, I think, maybe. I don't know. We'll do the best we can. This world's crazy. There's horrible people out there, but there's great people like you. So keep on being exactly how you are. But for now, I've got nothing else. So go away. But thank you for being here. And thank you for being you. Bye.